is Wenisha Yiling and I will be explaining about agency. The law of agency in Malaysia is governed by Part 10 of the Contract Act 1950. Agency is a triangular relationship that constructs the creation of legal relationship between a person, which is the principal, and a third party via the intervention of agent. Section 135 of the Contract Act 1950 defines agent as a person employed to do any act for another or to represent another in dealings with third party. Section 136 of the Contract Act 1950 defines principal as the person for whom such act is done or who is so represented. Termination of agency, in which an agency relationship can be terminated. Termination means the ending of the contract of agency between principal and agent. Termination can be done in three ways, which is by agreement, by performance, and by the principal revoking the agent's authority. Termination of agency by agreement happens when both parties desire and agree that the agency shall be terminated. Therefore, the agency is terminated. Secondly is by performance. According to Section 154 of the Contract Act 1950, the Contract Act of the agency ends when the agent has performed the contract. Last but not least is by the principal revoking the agent's authority. The principal may revoke the authority of the agent at any time before it has been exercised to bind the principal. The principal can revoke the agent's authority where the principal gives notice to the agent and the agent is in default under the agency. However, the power to revoke the agency by the principal is limited to based on Section 55 of the Contract Act 1950, the agent has an interest in subject.
Hi madam, my name is Inshira binti Sari. Today, I am going to present about scenario of termination of agent by agreement, performance, and principal revoking the agent's authority. The scenario of the termination of agent by agreement is when they hire a financial advisor to manage her investment, but after a few months, she felt that the advisor's strategy were aligning with her goals. Instead of prolonging the dissatisfaction, Wendy and the advisor had an open conversation and mutually agreed to terminate their agreement. The scenario of the termination of agency by the performance is Esther hired marketing agent to promote her business, but after several months, she noticed that the agent was delivering the promised result. Despite repeated discussion and warning, the agent failed to meet the performance expectation outlined in their contract. As a result, Esther terminated the agent's service due to their inadequate performance. Lastly, the scenario of termination of agent by principal revoking the agent's authority is Shira appointed a power of attorney to handle her financial affairs while she was traveling abroad. However, upon her return, she discovered that her attorney had been making unauthorized transactions and mismanaging her assets. Shira immediately revoked the attorney's authority and terminated their relationship. Let's talk about introduction of Nemo that quote not habit rule. As a general rule, a person takes goods, example buyer, he or she gets only the same right to the goods as the person from whom he or she took them. Example seller. Based on Section 27 of Sale of Goods Act 1957, if the goods are bought from a person who is not the owner and who does not sell them under the owner authority, the buyer does not acquire any title.
name is Esther Penelope Anakjanet, and I will be explaining about 3 exceptions of Nemo that quote non-habet rule. The 3 exceptions of Nemo that quote non-habet rule that I will explain are estoppel, sale of mercantile agent, and sale by a buyer in possession. The first one is estoppel. Estoppel means where the owner by his conduct makes it appear to the buyer that the person who sells the goods has authority to do so, and then buyer relies on that conduct. The buyer obtains a good title because the owner is precluded by his conduct from denying the seller's authority to sell under section 267 sales of good act. The example scenario for estoppel is Inshira sells Wendy's business to John. Wendy is present when the sale is made, but she makes no comment, nor does she say that the business belongs to her. Here, Wendy's conduct convinces John that Inshira is the owner of the business. In such case, Wendy, because of her conduct, cannot later say that Inshira had no right to sell the business and John will have a good title to it. The second exception is sale of mercantile agent. A mercantile agent is the person whose ordinary business is to sell goods or consign them for sale, or to buy goods or to raise money on the security of goods. According to Section 27 Sale of Goods Act, where a mercantile agent is, with consent of the owner, in possession of the good or of a document of title to the goods, any sale by him when acting in the ordinary course of business of a mercantile agent shall be valid as if he were expressly authorized by the owner of the goods to make the same. The example scenario for the second exception is Wendy gave her business to Inshira, who was her agent, with instruction not to sell the business below a certain price. Inshira sold the business to John at a much lower price and kept the money with her. John had bought the business in good faith and had no knowledge of the direction that Wendy had given to Inshira. In this case, Wendy could not get the business back from John as the property already passed to John. The last exception is sale by a buyer in possession. Based on Section 30, Clause 2, Sale of Good Act, 1957, if a buyer, having bought or agreed to buy goods, obtain possession of the goods or the document of the title with the consent of seller, he can pass a good title to a subsequent buyer acting in good faith, even if under the first transaction he has not obtained a good title. And the example scenario for the last exception is Inshira sold her business to Aurel, who paid by a check. Although he was given possession, it was agreed that the property would not pass until the check was honored. The check was dishonored, but Aurel had resold the business to Becky, who bought it without knowledge of the possession. Becky resold it to Claire. Inshira tried to recover the business from Claire. So the hell is, Aurel, the original buyer, was in possession with the consent of the owner. Hence, she could pass a good title to Becky, who in turn transferred it to Claire. Claire was, therefore, entitled to keep the business.